Thank you for joining us tonight. My name is Anna McCall. I am the Member Engagement Manager at Lincoln's Inn. We also have my colleague Jade, who is the Member Engagement Coordinator. Thank you for coming along to the event tonight, where we'll be discussing probationary tenancies, formerly known as third sixes, tenancy applications, and also the general experience of pupillage and second sixes. We hope the talk will last for around an hour, including a 15-minute Q&A session. If you do have any questions, please can you put those in the Q&A box rather than the chat function, and then we'll get to those at the end. I'm now going to hand you over to Anthony James, who is a barrister at Mountford Chambers and who is also a member of the Inn's Junior Members Committee. Anthony will be chairing tonight's event.
Anna, thank you very much. Good evening, everyone. Yes, I'm a junior tenant at Mountford Chambers, and we're predominantly a criminal set. We also do a bit of regulatory work, inquests and public law, but the majority of my practice is crime. I was called to the bar in 2021, but started pupillage actually the year before, and because of COVID, I was all delayed. So I got on my feet in April 2021, and I was taken on as a tenant in January 2022. So I've got a fair idea about the second six process, and also, as is common in a lot of criminal sets, that extended second six, as it were, before being taken on as a tenant, and give you an idea about some tips about second six, I hope, and junior tenancy. I'm joined by two excellent speakers. The first is Ciara Moran, who you'll see on screen. She's a tenant at 4 King's Bench Walk Chambers. She completed her pupillage in October 2022. Ciara has a broad common law practice across all of Chambers' practice areas, but she has a particular focus on criminal defence, immigration, public law, and family law. And Ciara was also lucky enough to be at bar school with me. We also have Abiodun, who joined 36 Public and Human Rights upon completion of his pupillage at a different set, a leading human rights set. He accepts instructions in public law, human rights, immigration, employment, housing, and media law. Before coming to the bar, Abiodun established a reputation as a leading commentator on the rule of law. He's the convener of Citizenship and the Rule of Law, an online course with over 20,000 students from every country in the world. He's widely published in a range of academic areas, including public legal education, equality law, the effect of technology on human rights, and the regulation of the legal profession. What we're going to do is almost take a chronological approach, I think, this evening. So we'll start, all of us, giving some insight into how we found our pupillages, maybe a bit about our first six, but particularly we want to give you some advice about second six, what it's like at the start. I'm sure lots of people on the call will have just been on their feet maybe a couple of weeks. And as we know, particularly in areas of crime, that can be a pretty full-on couple of weeks. And then Abiodun obviously has got a lot of insight for you about third sixes, probationary tenancies, as they're called now, applying for those and what it's like doing those and the transition into tenancy. So I'm going to start by asking Ciara to tell us a bit about second six, some tips she may have for people that maybe are at the same stage themselves.
In terms of tips, I think my biggest tip is fess up often and fess up early. Second six is, particularly in a criminal set, as Anthony said, exhausting, overwhelming, fantastic. I loved it, but it is a lot. And it's very likely that you'll make mistakes, or if you don't make mistakes, you'll feel like you have made mistakes. And in both cases, the easiest thing to do is call somebody immediately. I was very lucky to do my second six at Chambers. It was incredibly supportive, in an atmosphere where I felt that I could ask for help early and often. But this is not a career that anyone gets ahead in alone. And it may very well be that you have done fantastically, you've done everything right, but even then having the reassurance at the end of the day so that you can put the day to bed is something that I think you really, really need. So just total, absolute blanket honesty with your supervisor if you have that relationship, with your mentor if you have one. But in any event, identify the people you can talk to and do.
Thanks, Ciara. You obviously have a broad practice. So when you were a second six people, I imagine that you were doing a real variety of work. Would you say that there's a difference in approach as a second six people depending on the areas of law you're doing or anything like that?
Yeah, absolutely. I mean, I suppose the biggest difference is my friends in commercial sets who did very little advocacy work, for whom second six was much more a continuation of the first six approach. of having a predominantly paper-based practice, of completing work under other people, versus those with a common law criminal pupillage who will find themselves in court almost every day from the outset. But I think the advice is the same either way. The more responsibility you have, the more you should be reaching out to those around you for support with it.
Lovely, thanks very much. Abiodun, I'm going to put the question to you now. If you could tell us a bit about your second six and any advice you have for people who maybe at the same stage.
Certainly. So I was actually in one of the slightly more desk-based, paper-based second sixes that Ciara was describing. So I think what I'd get across is find ways of making it interesting. I had very little advocacy experience by the time I'd finished my second six. And in retrospect, I wish I had gone into the clerk's room a little bit more often to ask for whatever hearings were around so that I could actually get the experience of being in front of a judge before I went off and did my own thing. So if you are in the situation where you have, as a small number of chambers do, a second six which is split into two halves, where the first 3 months are more of a continuation of the first six, try to get as much advocacy experience as you can, because it may not be forthcoming and you may get to a point slightly later than most do where you're a fledgling barrister having never convinced the judge of anything and you're not sure of your abilities. So definitely make sure you get as much advocacy experience as you possibly can. This sounds like a bit of a sort of parental thing to say, but my second piece of advice is it's not your money. And I think that one of the sort of really startling realizations that I had during pupillage was that in a very short time frame after I would finish, I'd have to give 100% and another 50% of my tax earnings to HMRC, and I would just make sure that you're saving as much money as possible in a really practical way to save yourself a shock slightly later. And I think I definitely support Ciara's previous comments about how you should always immediately talk to someone more senior with more experience if you're worried about something. And I'd also say that I saw my second six as a continuation of the learning experience, and I was still asking senior people what felt like stupid questions, but obviously there are no stupid questions. As my second six went on, and I felt that it was deeply enriching for me to be asking someone, how would you put the argument, and is this the most recent authority, etc. And those were conversations that were very helpful to me in developing my skills and confidence.
I'm sure Ciara and I find it quite odd to think that someone would actually be asking for more work in second six when you're in a set that does criminal law. It's sometimes the opposite, but that's a really interesting insight. I think on the asking for advice point, I think that's vital. I remember my first couple of weeks being on my feet, and just everything you do is new every single day. You're doing crime, you're in a different courtroom, and you're doing a new thing. I remember day one, I was able to prep it quite a lot because I'd had the case a while, but my second day, I just got the case there and then at court. It was a driving case. So I knew very little about driving law. So I needed to really take time both to look through the practitioner's text myself, but also I had to be on the phone to several people, particularly people that had done quite a lot of driving law, to get their advice about things, to check over a couple of things. Is that the kind of advice you'd be giving? And honestly, I just don't be afraid, I'd say, to reach out to people. I think the job gets so much easier once you've sort of seen everything once. I think honestly, 2 or 3 weeks in magistrates court every day, you've then probably done most styles of hearing and things become a lot easier. One of my favorite parts of my career so far was that summer of second six, where I'd pretty much seen everything in the mags at that point. I was pretty comfortable now in the mags. The weather was great. Lots of other friends at the bar through the inn and things, and we were all having a good time, and it really is good fun. And I hope everyone would support me in that. But then, of course, in crime, you get up to the Crown Court and everything's new again and things are really difficult and you're on the phone again all the time. Or you get to my stage 3 years in and suddenly you're doing a particular type of case that's new to you. It could be a sort of start going to sexual offences or something, and then again you're going to be on the phone to people all the time. So it's a learning process that doesn't stop, and it's just really important to keep that up. I think most chambers now have these juniors WhatsApp groups. I'm sure you guys do as well. And those are a great resource just to put out, can someone please call me? Or actually, if you've got a little bit more time, this is what I'm thinking of doing. How does that sound? And getting some feedback from people. Some other advice from me, I think doing the basics is really, really helpful. I hated those case analysis sessions we used to do at bar school when they said, "Oh, write out the charge, break the charge down, do a dramatis, do a chronology," and things like that. But actually, I now do it for every single case, and I've done that ever since Second Six, because it's just a really good way of getting into a case in the first place, and then having that crib sheet, as it were, to look down if you forget a detail of a witness or that sort of thing. I found is really useful, and I've carried that on since. And lastly, I'd say make extra effort with solicitors. Give them a call after the hearing, let them know what's happened, to update them what's happened to the client, etc. Solicitors really appreciate that. Let them know that attendance note's coming. It might be later today or maybe over the weekend, but let them know it's coming, and try and get the attendance note over to them as soon as possible. It's never too early to start making a good impression with solicitors. And perhaps on that, Ciara, do you have any views on how to do a bit of maybe networking and how to build your network with solicitors from an early stage, especially as a pupil?
Something I think it took me a while to get used to in Second Six was solicitors asking for my advice. I remember getting those first emails that said, you know, counsel, what do you think we should do with this? And just being sat there like, I've been doing this 3 weeks. You tell me. But actually, you should be taking a view early on. You should be having those conversations with the solicitors. At your stage, there will be more conversations than instructions. But solicitors really do appreciate it if you can. If you look at the case papers and there's something that occurs to you, get in touch as early as possible. Look at your papers as early as possible. I had a set of papers at one point in Second Six in which I suddenly realised that another person in chambers was involved tangentially in the case, and I had to return it. And that was a case I hadn't actually looked at until very, very close to the hearing, and it did not make a good impression when I returned my papers 2 days before, suddenly saying, "Oh, I've got a conflict." So even if it's something where you look at it and you think it's not going to take me a long time to prep this, look at them as soon as you get them. Email the solicitors as soon as you get them. If you think there's an obvious issue with the case, if you think there's something your solicitors might have overlooked, perhaps it happens, or even if they haven't overlooked, there's something that you can see the judge commenting on, let them know before the hearing, not after. Because then you're the person who warned them, not the person just sending them an attendance note saying, "Yes, we lost," and on something that I could have told you about before. So it's proactivity at every stage. And I think a big thing for me, the pupillage was actually my first. I came to the bar relatively young. Pupillage was my first full-time job. And so for some people, this advice is going to seem completely obvious, but I was 23 and I maybe needed to be told. People don't care if you're 100% the best, but you can't get things done. People care if you can get things done. Sometimes good enough just has to be good enough. If you're sending an attendance note that's roughly formatted but is sent on the day, that's better than typing up these incredibly long, beautiful notes that then take you a week to send. And so you have to find the balance for yourself of what you can do versus expectations that are simply too high and actually lead you to let people down or send things too late. So figure out how you can be a person who gets things done and who can be relied upon to get things done to the standard necessary, because that is what is impressive.
Yes, I completely agree with that, Ciara. Abiodun, do you have any insight into your area of law and that relationship with solicitors? I don't know if it differs from our areas.
Oh, it's much the same. I think in addition to the things that have already been said, I would say that sending solicitors things that they may not have the opportunity to have come across is often deeply appreciated. So I know that one of my solicitors has a particular spate of cases against one particular social landlord, and I sent them a judgment that was going to be quite helpful to them in a number of other cases that they're running in which I'm not involved, that I think might help them to, where they are pleading, produce better defences. I think that's one of the ways that you can really add value if we as people who are deeply engaged with case law and new developments, and giving them to solicitors who are often quite stretched and pressed for time. That's something that shows that we're experts who care about what their growing pains as a business are. It's a bit of a a millennial Gen Z thing, but I always add them on LinkedIn as I've just done to both of you. And yeah, I just find that it's the laziest and easiest way of getting the things that are impressive about you in front of them without having to do more work. So that's something that I always recommend. And having a presence there, I think, is again a slightly passive way of getting across your superstar moments. I have a pro forma attendance note that I fill out with the current month, and I have a couple that have a sort of bespoke paragraph for each of my areas of practice. I find it saves me a bit of time. So yeah, I think those are the main things. And then I think the other thing is remembering that solicitors are social creatures as well, and like all human beings, they do just want empathy and a high level of emotional intelligence. And just sometimes remembering the kid's birthday, or saw that this thing hadn't gone very well in your business generally. How are things now? Yeah, just doing the social thing, I think, is also quite useful for nurturing the relationships.
On that social side, obviously that barristers' chambers tend to put on drinks events and tend to go to other events and that kind of thing. And solicitors are there and other people are there. Have you got any tips, either of you, how to manage those situations in second sixer? Because I think it can be a little awkward sometimes. I think my chambers, we tend to consider that the pupils as nearly members of chambers, and that they're entitled to be there the whole time. We fully get them involved in all our events and that kind of thing. But I know some chambers it can be a little bit different. Do you guys have any insight in that?
My chambers, I think, takes a very similar approach to yours, Anthony, in that by second six, if we've decided that you're fit to represent chambers in courts, you're also fit to represent chambers at social events. And so pupils aren't expected to, I know some chambers have a one drink rule, for example, for pupils at networking events. No, we don't have anything like that.
But that being said, obviously, I think moderation would
Yeah.
be
Yes.
advised.
Be sensible.
Exactly.
Yes, exactly. I think a very good tip I did get from a girl we also went to bar school with, Anthony, who managed to get quite a bit of work actually in her second six out of this, was that she said that when a solicitor rang her about a case, she would watch the timer on her phone, measuring the time of the call, and she wouldn't ask a question about the case until it had been a full minute. So she would make herself, obviously exercising judgment in terms of, are you in a time crunch? But if there was the opportunity to do so, she would try and make a full minute of small talk, building the relationship before she got on to saying, oh, and what are we doing about this application? And she said that was something that she felt built relationships for her really quite quickly.
Have you done anything to add on that point?
I would set, as much as is possible, I would always advise people at all stages of seniority in any profession to have an existence that is professionally interesting outside of their immediate job title. So I remember at my previous set, we had a big sort of promotional drinks thing for commercial firms from around London. And obviously I had my big badge on saying I'm a pupil. But earlier that week, I'd just been on a panel with Lady Hale, and several of the partners and senior associates in the event had seen that event, and that they would sort of literally walk around the KCs to talk to me because I had done something that was interesting. And I think that there may not be you know, to be frank, things that are of interest to some of the people that you might wish to network with in regard to your life as a pupil. But if you've got an interesting voluntary life, or you've been writing things about developing areas of law, I would see that as good fodder for a conversation around the canapes at some of these events and socials. And I would do the intelligent strategic work of working out, you know, what has this person been sharing or talking about in other circles. What do they post about? You know, is this partner of this law firm someone who's interested in AI, for example? And then try to meet them with their wider interests, rather than talking about the sort of junior level cases that you're currently working on. And I found that I've been able to create relationships with people who are significantly more senior than me, because I've shown that I have these wider interests. And I suppose in the other profession, uh, what do they call that? Commercial awareness or whatever.
Yeah, the buzzword for any undergraduate law student. Yeah, absolutely. Now we've had some questions come in about third sixes, so I know people want to get on to talk about probationary tenancy and things. So we'll just end by, I think, Ciara and I can give some insight into the process of applying for tenancy at the chambers you've done a second six at. I know at our chambers you're given an invitation to apply at some point, and that doesn't happen after 12 months exactly. It doesn't happen in the October, the year later. For us, it happens in sort of January, February, maybe slightly later, because it's so important to get an idea of what a pupil's like on their feet, particularly in crime. First six can only show so much for a criminal lawyer. Second six really is the crunch time in that regard. And I know for our chambers, you were invited to apply, and then it was a written application, and in that you gave them a list of cases that you thought were notable, and then also 3 written pieces of work which had been appropriately anonymized. So I think a bit of advice is, and this applies for various reasons, is to just keep a running note somewhere in OneNote on your laptop, whatever it is, about some of the cases that you think are particularly notable, whether it's a particularly niche area of law, a really good result, a vulnerable client, a difficult piece of cross-examination, whatever it might be. Keep a note of those things. And this is useful for a variety of reasons. It's useful for your application for tenancy. It's useful for your probationary tenancy applications to other chambers. And also, once you get tenancy somewhere, it's really useful to copy and paste it onto your website profile. So that's really handy. And also keep a note of some of those written pieces of work that you think are particularly noteworthy, the ones that you'd want to put forward, because I'm sure they're going to be needed at some point. Is there anything you'd like to add to that, Ciara?
No, I don't think so. I think that's the best advice you can give. At our chambers, you're also expected to add references from solicitors that have worked with you. And so keeping a note of people for whom you've obtained particularly good results or developed a close working relationship can also be useful in that regard. But otherwise, I think you've covered it.
Lovely. So turning to probationary tenancies, and Abiodun's going to have to do the heavy lifting on this one. I think perhaps a good question to start with is one on the Q&A section. It says, I don't want tenancy in my current set. At what stage of second six do I start to look for probationary tenancies? Could you give us some insight on that, Abiodun?
Yeah, definitely. So I did want tenancy at my training set until about August or September. So I had made an initial application, it was not accepted, and then I was asked if I wanted to make a second application around that time, and then said no. And I think I made my Volt FAS a bit too late to get all of the options that I could have had. So I think you probably have all of your options available to you if you start looking for third sixes, sorry, around June or July. That's when the majority of sets who will be recruiting over that summer window will start getting them out.
Where do you, sorry to interrupt, Abiodun, where can you find out which sets are recruiting?
Yeah, there's a Bar Council probationary tenancies page, and I'm not sure of the status. It's either heavily encouraged or mandatory that probationary tenancies go on there. I did see about 2 or 3 probationary tenancies for sets I was interested in, which did not go on there in that period. But aside from that, everyone else did put their vacancies on there. And I would think that if you are in a position to make applications around June or July, you give yourself the best shot of getting your area of law in the area, in the geographical area that you want it to be. However, all is not lost if you don't get something in before August. That page has rolling vacancies. It has vacancies that have quite extensive windows of recruitment. I think there's about 40 vacancies on there that have been there for longer than a year. And I did find several vacancies after August, one of which was successful. And I actually found it really interesting to examine the possibilities for what I might get involved in at the start of my career that came from that page. And it was actually, obviously it was terrifying to be in that position, but it was also really exciting. And I started to think about additional areas that I might get involved in if I were to make an application to a set that did work that I didn't do during my pupillage. And though I did eventually come to the view that I probably was a public lawyer and did apply to a set that did it, I did look at a couple of other areas, particularly to specialize in employment and commercial law. And yeah, I did make some applications to places that I had interviewed at in my applications for pupillage. And it was interesting to understand what their view of my development was. And as an applicant for probationary tenancy, you really do have conversations that are really informative about the market's view of your development that you don't really get to have at the very, very, very early stage of pupillage. And these might be the sorts of conversations that a junior has when they move chambers as well. But I did feel as though I came to a more mature and holistic understanding of my development as I was talking to these chambers about how well my pupillage had gone. And I personally thought, in a sort of defeatist way, that it had gone really badly, but it was really pleasing to me and somewhat comforting to know that that was not the view that similar chambers had. So yeah, I found it initially very daunting, but once I realized that new vacancies that I was interested in were going to be released, I was able to have a great holiday. Went to Mozambique for a week and flopped about in the Indian Ocean, came back, made some applications, and I managed to get something. So if you don't get something in by August, don't worry about it. Things will be available in late August and September.
Yeah, I certainly have a friend who was in the same boat. He wasn't taken on at the end of his pupillage. I think he got the third six and then went on the holiday, but I don't think that's an issue at all. I think crime's an interesting area for third sixes. I think someone's written on the Q&A is finding a probationary tenancy as hard as finding a pupillage, and this is something I talk to students about quite a lot when I do events at the inn. Actually getting our foot in the door is the really hard bit with crime. That's where the bottleneck is. Actually getting a third six. Chambers are really keen to take on third sixes, particularly in crime, and the reason for that's twofold. The first is you don't cost a penny as a probationary tenant, because they don't have to pay you guaranteed earnings. They don't have to pay 6 months worth of guaranteed earnings to a first six people who won't do any work, on their feet, I should say. And they don't have to provide any advocacy training or that sort of thing to those people, albeit lots of chambers do, including my chambers. So you don't cost the chambers much at all. and you can do all of their lower end work, which is hard work. It's exhausting for crime, lots of magistrates court work, etc. But it's work that keeps chambers going because it services the work for the solicitors to bring in the Crown Court work for more senior members of chambers. So you're providing a really important role there, and you don't cost the chambers an awful lot of money. And fundamentally, at the end of the probationary tenancy, if you're not quite up to scratch, they don't have to take you on. So it's win-win-win for chambers. So actually, the market for a probationary tenant in crime is very good, and also chambers can move extraordinarily quickly. Obviously, there will be a lot of people looking for third sixes around that October time, the year after the pupillage. But actually, as I said, with crime, pupillages tend to be a bit longer. So people will be finishing pupillage at all sort of different times. So you might be finishing like me in January, you might be finishing in February, maybe the November before. And therefore, if you haven't been taken on or know you don't want to be taken on, then you can take a look for those probationary tenancies. They will interview you very quickly, and they will offer very quickly as well. It's usually just a one interview thing for a criminal set. So yeah, you're in a really good position as somebody looking for a probationary tenancy, particularly in crime, and they can move quickly. And I think an interesting thing, might be interested to get Ciara's insight on this, is keeping it quiet if you are thinking of moving. I think this applies maybe more so to people looking to move as a tenant somewhere else. But actually, of course, you might not want the chambers you're moving from to necessarily know that you're looking for third sixes. And most chambers will be, well, almost all chambers will keep the fact that you've interviewed with them confidential, I'm sure. Ciara, do you have any insight onto that side of it?
Just in relation to what you said initially about the market for criminal pupils, I'd say in my experience, although not quite as good for family pupils, there is similarly quite a good market for family law third sixes for much the same reasons that there is a lot of work that has to be serviced to enable a senior member of chambers to keep those relationships sweet with solicitors. So while not quite as good, it is still pretty good. In relation to confidentiality, I would say it is really important. Of course, whilst you might have made your mind up that you don't want to stay at the set that you're at now, you also don't want to burn the bridge too early. You might be unsuccessful in your applications for third sixes, although I would imagine unlikely. And you may end up deciding that you want to remain at your set a little longer to qualify there and start practicing there. And so the convention is don't tell anyone. You may have a co-pupil, you may have a mentor that you can speak to in confidence, but broadly the done thing is to make sure it's confidential. Mark your emails, mark your letters as confidential. Most of the vacancies will say we treat applications in the strictest of confidence. But it is something that it is sensible to have a little bit of discretion around, just because you don't want to limit options for yourself before having had those interviews and outcomes.
We've had a question about can we give insight into the interview process for probationary tenancy? And of course, it's going to differ from areas. I didn't do an interview myself, obviously, because I was taken on, but I have been on the other side of the table interviewing people who have come to us for probationary tenancy. And I think with crime, we tend to have started with an advocacy exercise. So we got them to do what was quite a knotty youth court sentencing, which had some legal issues, but also want to see the sort of rhetorical flair as well from the candidate. And then we'd ask about their pupillage to date, getting an insight as to why they want to leave, an insight into the kind of work they want to do. And also we will ask them a little bit about what kind of work they might be able to bring into chambers, if anything. That again applies more to junior tenants moving over, but still third sixes, probationary tenants, we'd want to know a bit about that. And I think lots of chambers, the first point of contact will be the senior clerk, and that senior clerk will want to talk to you if you're someone applying for a probationary tenancy, want to talk to you a bit about the practice you've had and the kind of work you'd be willing to do and wanting to do when you come into that chambers. Abiodun, can you give us some insight into the interview process as someone who's been through it in a course in a different area of law?
Yeah, sure thing. So this might sound like a slightly cronyist thing to say, but I think one of the best ways to start as an applicant is to talk to current clerks within your chambers to see if there are unadvertised vacancies that might be available at similar sets. Clerks know each other, clerks know the market, and they will be able to give a nudge to say, this person's really good at this, but this person here thought they weren't so good at that. is there a possibility you can consider their application? So I did actually have about 3 or 4 of those referrals from clerks to clerks, putting a sort of pro forma application in my CV to senior clerk, anyone operationally, and head of pupillage. In terms of the interview process that I went through, I did have an advocacy exercise, and very similar to what we've just heard. It was a combination of a slightly annoying legal problem where they wanted to see that I could convince a judge in a short span of time of something that they may not have been convinced of otherwise. So in many ways, it shared similarities with a second round pupillage interview, and a second round pupillage interview with much less stress, I should say. I was then asked extensive questions about the areas of law that I was engaged in, questions about my age debts, questions about what I could bring to chambers, and I suppose that there was a tension between areas of practice that chambers clearly did and which would definitely be done by a junior, and things I had chosen to omit from my form. And I did feel as though there was a sort of persuasive exercise that the panel was doing on me to say, will you do this relatively frustrating hard work that we don't think you've done before, which we really need someone to do, and me being convinced over a period of about 5 or 10 minutes that if I said yes, I would get it. So yeah, 6 months later. But yeah, that's the process that I went through.
Yeah, I think that's an interesting point to make. It's for junior criminal barristers, we do Saturday court. Ciara, did you have Saturday court? If you can nod or shake your head. No, you didn't. Lucky you. I had a whole year of Saturday court until the pupils below me got on their feet, and so I was working pretty much 6 days a week for that first year. People who come in and do probationary tenancies in my chambers and in most criminal sets, they'll be expected to be on the Saturday court rota. So although you may be as senior as somebody who's a very junior tenant, if they were taken on at the same time you came in as a probationary tenant, you're not quite on the same level, as it were, because you'll still be doing things like Saturday court, and the work you're doing may be slightly more knockabout, maybe more of that servicing work because of the nature of the fact that you are a pupil. And that's, I imagine, quite frustrating for some people, but it is a period that does come to an end at some point, and you will get tenancy somewhere and your practice will start to change. While we're on that, actually, we've got about a few more minutes before we turn to some more Q&A. Let's talk a bit about tenancy and what it's like moving into tenancy. So, Ciara, could you tell us what it's like becoming a tenant, how your practice changes, maybe talk a bit about finances and paying rent and that sort of kind of side of things?
Yeah, absolutely. I think the big thing for tenancy is you have that sudden feeling when you go into second six, when you're sort of on the tube to your first case or whatever, and you think, oh my God, I'm all by myself. Like, where's my supervisor? Who's looking out for me? Does anyone know that I'm here? And then you become a tenant and you're entirely unsupervised. And I think there is, having spoken to my co-pupil, both of us found that initial sort of having taken tenancy in October, that November, December quite difficult, because we were functionally for the first 2 months or so doing the same work we had done as a second six pupil, but without our pupillage awards, without any guaranteed earnings, paying rent for the first time, and without or maybe what felt like without the previous support of a supervisor. But actually what ends up happening is you build new relationships with your chambers, relationships in which you are an equal and not a pupil, and that's a wonderful thing. Finances you will get a hang of. I think Abiodun mentioned earlier, save early, don't let that get on top of you. I recently filled out my first tax return as a self-employed person, and where's my money? Like, where did it go? So definitely get into the habit of saving early. For me, knowing that I was planning on going into crime heavily so at common law sets, I took my pupillage award for longer than I strictly needed to so that I could build up a cushion. And I would really, really recommend that, because for the first couple months of your tenancy, particularly if you've only done 6 months of second six rather than an extended second six, the money isn't coming in yet, not in the way that it should be compared to the amount of work that you're doing. Particularly in crime, if you're doing legal aid family as well, payments can take a really long time to come through. My age debt is huge. And so having a cushion is really, really important. And so, yeah, I took my pupillage award for longer than I strictly needed to. And I'm now repaying that, but I'm repaying it knowing that I've always had at least 6 weeks living expenses as a buffer in my bank accounts. I was told to treat my pupillage award as essentially a 0% interest loan, which is what it is, because the part that is above and beyond, so having earned above and beyond the guaranteed earnings, I'm now repaying some of it. But having that money in the bank for times when the legal aid agency aren't sending you any emails and aren't picking up the phone is so important. And it also just means that you're not spending the first months of tenancy scared financially. You can focus on doing what you need to do. Aside from that, I think we have a maximum chambers that the clerks know exactly when you get comfortable. Every time I've got to the point where I feel like I've seen everything that I'm doing at least once and it's all okay, I suddenly get a call for something much scarier than anything I've seen before. You're not really allowed to rest on your laurels, unfortunately. But that has been a really good thing, because my experience of tenancy has been constantly growing. And yeah, being now an early second year tenant, I find that I'm managing so much more than I was in second six, doing things that are much scarier. Emotionally speaking, your capacity to deal with things, your capacity to deal with mistakes, with difficult clients, with difficult solicitors, and your confidence in yourself is going to grow so much that even doing much harder work, you will feel so much better. I remember in second six going to a friend in chambers who's a few years ahead and basically saying through tears, is it always going to be like this? And she said, yes, but you'll learn to deal with it. And that has been the truth.
And you become a lot quicker at dealing with things as well, and a lot quicker at picking things up. When you get that first case of a particular type when you're very junior, it's really daunting and you really takes time to go through it. But actually, you pick up skills so quickly in this job, and you're able to open a case and read a case and get to grips with something much more quickly, aren't you?
Absolutely, yeah.
Yeah. I think when you become a tenant, because you have then ability to say a word the clerks hate, of course, which is the word no, from time to time, you've still got to be aware of the fact that you are always building a practice in this job. And also the clerks are very important, and keeping them on side is vital. And that relationship with the clerks is a whole other Zoom webinar that we could do. But being somebody who's willing to take things on, being somebody who's a team player and willing to get the clerks out of a hole when they need you to, when you've just left court and you're just about to get the train home and they ring you saying, Anthony, breach of bail at Barkingside Magistrates via video. I've got no one else. Can you jump on? Sometimes you can say no, of course, even as a tenant, but actually saying yes, getting them out of a hole, it keeps you popular in the clerk's room. And when those briefs come in, the ones you really want, the big cases, the opportunities that you want the clerks to be putting you forward for it. So don't underestimate the fact that even though that you're no longer a pupil and you're no longer bound to say yes to anything, there is a lot of benefit to still saying yes to things within reason and keeping your sanity in the job, which is easier said than done. Are you doing anything on being a junior tenant you'd like to add?
Not quite there yet, but hopefully next month. And
Oh, sorry.
yes, I suppose from the position I'm in at present, I'm just trying to get my fingers deeply embedded into the sofa. So I have said I'd take part in seminars for solicitors after the end of my third six. I have got bookings running through to July for hearings, and just trying to do the sort of promotional activity that everyone else is doing in terms of writing articles and blogs for our website and LinkedIn and whatnot. So even though I am not myself a tenant, I'm trying to make the contribution that everyone who is a tenant is making.
Brilliant. All right, we have a few questions still to answer on the Q&A part of the call. One of which is, what are some common challenges faced by barristers during their second six, and how can they overcome them? Ciara, do you want to take that one?
Yes, absolutely. Although I'm also going to grab my laptop charger. So please do excuse me while I'm moving.
Exciting.
So I think common challenges, the first being, as Anthony said, it's your first time seeing everything. And so there are issues that could come up, procedural quirks of law that you haven't.
I think we may have lost Ciara. She moves around the room. It was like a scene out of the West Wing.
And the judge will say, well, counsel. Oh, sorry, did you lose me?
Sorry, Ciara, you cut out. You cut out just as you went down the corridor. Do you want to row back to it?
Sorry, so I was saying that particularly for me, I did a common law pupillage, and so I was expected to familiarize myself with a huge number of areas of law very quickly. Every hearing is of a different type. Every hearing has its own set of procedural rules, own set of guiding principles. There will be stuff that you forget or that you just don't know because you haven't seen it before. And so at least for the first few weeks, talking through everything you can before you do it with somebody more senior than you, if your chambers is a place that's open to doing that with you, I think is so important. A big thing for me was 2 weeks into my second six, I wasn't aware that committal for contempt hearings, even if heard in the magistrate's court, are always robed. And if I had just said to somebody the day before, I've just been given this brief for committal, I could have avoided a very panicked note sent to the judge asking for permission to appear in front of him without my wig. And so just talking everything through, because there will always be things that you miss. There will always be things that just haven't come up in first six, because 6 months is not long enough to become acquainted with all of the intricacies of your area of law. And I think the other thing is building your client's confidence in you. Depending on your area of law, your client may well have been told that you are a pupil. I'm fairly certain there were a few hearings that I was employed in because I was cheap and available, and my client was probably told, look, you're getting a pupil, but that's what you can afford, and she's from a decent set, so she should be okay. I'm certain that was my calling card for a while. Building your client's confidence in you as a second six pupil. Firstly, I think remembering everything you can about the case, even the things that don't seem important, even the things that aren't going to make a difference to the outcome. Like Anthony said earlier, doing a case analysis, doing a dramatis, doing a chronology. If you can say, if your client says to you, my daughter, and you say Sarah or Rosie, that is instant connection and instant trust. And I have a client say to me, I'm so glad it was you because you just knew everything about it. And I had to say, like, oh, I didn't say, what I didn't say was yes, because I wrote thousands and thousands of pages of notes before this because I was terrified you'd see me and not want me. So that's just such a quick way to build trust and faith in you, just to know everything you can about the case and make sure they see that you do. And another thing can be often losing sight in the legal arguments of what it is that your client actually wants. And I think I'm talking more about civil law here than criminal, perhaps. But something I always do now after being advised to by a senior member of chambers is, and it sounds so obvious, but at the top of your notes, write down what your client wants, what your client definitely doesn't want, and what the optimal outcome is, so that whatever comes up, you know, the judge may say, Miss Moran, I'm just not with you at all on your submissions. And you think, well, I know what my client wants, so here's my backup. So just having a clarity of purpose when you go into court means that you're not speaking at the judge, you're speaking with the judge. It changes your style from oratorial to conversational. And I think that's a really important thing that can make you look a lot more senior than you are, actually.
Brilliant, thanks for that. We had a question towards the start about gaining probationary tenancy on another circuit from the one that you've done your pupillage at. Now, I know none of us have been in that boat, unless Abiodun, no, you weren't. But the question is, can it still be worth building connections with solicitors if my aim is to gain probationary tenancy on another circuit? I think with crime, solicitors do tend to be quite geographically specific. So if you're moving from London to Leeds, you're probably not going to keep an awful lot of work. But it, of course, worth bearing in mind that particularly the solicitors down in London, they often end up with clients in other cities for some reason. I don't quite know how it all works, but or that client is from Essex and has gone and committed, he's gone on holiday or something to Somerset and has committed a crime there. If they know, they used to be at such and such set and then are a tenant up in Leeds or whatever, why don't we instruct them? That I think that could be important. And there's never any harm, I don't think, in building connections. Have you done anything to add on that?
Yeah, absolutely. I think that's right. In public law, there's a heavy skew where cases from all around England and Wales get heard in London. I think it's something like 60%, and often there'll be some kind of London involvement, like the Secretary of State for X made it, or there's a London charity involved that has a sort of regional function. So I yesterday was representing someone in the Employment Appeal Tribunal from Birmingham. I don't know if my accent did that or some other connection I've done in my past life, but yeah, I found that there are often very sort of serendipitous geographical relationships that you would never have thought might result in something, but do. So I think it's no bad thing to have, friends in different areas, and I certainly think that that's a good thing to do for somebody who's building a public law practice or a commercial or employment practice.
Yes, I thought that might be the case, particularly those areas that lots of solicitors will be based in London. Okay, we've got two more still to go. How does Second Six differ from First Six in terms of responsibilities and expectations? Now, obviously, in crime, they're just so different. You're able to do nothing. You're watching the piano player in First Six, and then suddenly, first day of Second Six, you're playing the piano without ever doing it before yourself. So yeah, it's completely different expectations and practice that you've got in that area. Abiodun, though, you might have a slightly different perspective because, as you said, you were a little bit more desk-based in Second Six. So how did your responsibilities and expectations change in terms of the desk-based work you were doing?
I suppose it was just that they were expecting it to be better. Yeah, so no more missing the legal point, no more not having exactly the right authorities, expecting you to be dead on with it. Um, they didn't trust us to do anything before the 9th month, so yeah, it was a big skew between how they treated us in the first 9 months to the last 3 months.
Ciara, anything from the different practice areas that you do?
No, I think all of my practice areas are fairly court heavy. So similarly to yourself, Anthony, it was Second Six and First Six were just completely different jobs.
Lovely. Okay. We've got 3 minutes. Someone's asked about transferring as a qualified lawyer, and they have an exemption, so they can do just a 3-month pupillage. And what's the best way to secure pupillage from that route? Now, it's a bit of a specific question. I don't really know the answer. Certainly, I've been marking the pupillage applications this year, and we had quite a few transferring lawyers who went through the normal pupillage process. I don't know whether it'd be worth emailing Chambers to ask them what they prefer, whether they prefer that through the normal process or through a different one. That might be a way of doing it. But of course, having experience in another jurisdiction is very useful, and certainly always piqued my interest when I'm looking at lots of applications and people coming straight out of university. Comparing them to people who've been in practice before and built a lot of their soft skills. It's certainly very useful. Does anyone else know the answer to that? Otherwise, I think perhaps emailing Chambers that you're interested in and asking what their approach is. I'm not sure what the regulatory position is as to whether they need to interview you normally. And then we have quite a general question. What types of cases or legal matters are typically handled by barristers during their Second Six? And how does this contribute to their professional development? I did pupillage at weird time because of COVID. All the Crown Courts were still socially distanced. There wasn't much Crown Court work. So it took me months till I got in the Crown Court. I was just doing back-to-back magistrates work stuff, shoplifting, lots of relatively minor domestic abuse, which is really good practice, cross-examining vulnerable complainants a lot of the time. That was really my bread and butter. But actually now I find lots of criminal pupils will be expected to be in the Crown Court much more because, one, there's no social distancing, and two, there's an enormous backlog and the Crown Courts are unbelievably busy. So I think there'll be a lot more Crown Court work for Second Six barristers in crime. Anything to add, you two?
I also did my pupillage at quite a weird time because I did my second six during the Crown Court strikes. So similarly, I didn't see a lot of Crown Court work in my second six. I did begin, once the strikes were over, cutting my teeth on PTPHs, sentencing hearings, mentions, things like that. But the first 3 months for me were almost entirely magistrates court work. In terms of family, normally you would start with things like non-molestation orders, occupation orders, the occasional DRA, first appointments. But I wouldn't say, I think I did an FDR, financial dispute resolution hearing, for the first time 5 months into my second six. And that was a huge deal. I was absolutely terrified. I don't smoke, and I smoked so many cigarettes that day. But that was my first exposure to that some months in. And in terms of immigration, which I also practice in, my first few hearings were a lot of bail applications, moving on to doing quite a few EU settlement scheme appeals, and then gradually moving on to more kind of gnarly human rights based appeals after that. But that was the progression of my immigration career. Abiodun, I don't know if you have any thoughts on that.
Really similar in terms of the immigration stuff, actually. So I had to do quite a few bail hearings that, weren't that very well prepared by instructing solicitors, I might say, at the start of getting into it all, until it progressed to more first-tier tribunal applications for asylum and refugee status. In terms of employment stuff, my progression was from applications and preliminary hearings to either trials or hearings in the Employment Appeal Tribunal, and the sort of more high courty public law stuff was initially around initial advice about people who made social care assessments or wanted to appeal social care assessments to actually representing them. So yeah, I suppose that's the progression in my areas of law.
Brilliant. Well, that's 1 minute past 7. That will do us. Thank you very much, everybody, for listening. We hope that's been of assistance. I'll hand you back to Anna.
Thank you. I was just going to echo that. Thank you so much for our panelists for joining us this evening. I think that was a really useful and in-depth discussion, and really great that you managed to get through all of our Q&A questions. If you do have any more questions, you can send them to us at Lincoln's Inn. Our email address is members@lincolnsinn.org.uk. We also will share a recording of this talk on our YouTube channel within the next week. But otherwise, just want to say a very big thank you, and hope you all found the event enjoyable.